That's all I have. Thank you.
Thank you, counsel. Appreciate the arguments. We'll call the last case of the day, Margery Fahey versus Albert Rocklein. Good morning, counsel.
Good morning, what's left of it. May it please the court, my name is Bradley Sherman on behalf of the appellate Margery Ann Fahey. This case is taken from Seminole County. I do want to point out that I have acted solely as appellate counsel in this case. Co-counsel, however, has acted as trial counsel and appellate counsel. The
Opposing counsel.
Opposing counsel.
Okay, oh, you said
Yeah.
co-counsel.
I may have.
There's nobody sitting over there.
I may have. The appellate, former wife, takes this appeal to the court, asking the court to find there's been abuse of discretion in 4 aspects of the final judgment. Denial of alimony, improper grant of set-offs against unpaid support, denial of the wife's request for equitable distribution of marital debt, and denial of attorney's fees.
You're not appealing the imputation of the minimum wage income to your client, are you?
As part of the denial of alimony, I am. Part of the trial court's finding, the final judgment's finding denying the alimony claim relies on the imputation.
But it also relies on the finding that the former husband did not have an ability to pay it.
Correct. This case, when presented to the trial court, came to the trial court with a circuit court order, a temporary order, that gave the wife close to $3,000 in temporary support, sole parental responsibility over 3 children, and a 24-year marriage. Testimony during trial was the former husband struggled with substance abuse. This is uncontroverted and uncontroverted in the record. The appellate's argument to this court concerns the trial court's failure to deal with facts, as I just referenced. In denying alimony and denying attorney's fees, the court failed to deal with these facts. Substance abuse, specifically the substance abuse. It was the record, there wasn't a dispute in testimony as to whether or not the husband had suffered for some form of substance abuse. The record shows that these parties migrated from the state of New Jersey, and the wife testified how it was a concern whether or not his pension can remain intact because he was almost let go from his job for cause.
Let me ask you hypothetically. 25-year marriage, husband and wife getting divorced. As they're leaving the marriage, they're in front of the trial judge. The evidence that the trial judge finds is the wife makes $50,000 a year and the husband makes $50,000 a year. The assets and debts are divided up equally. There's a request for permanent alimony by the wife and an award of attorney fees. And it's an abuse of discretion standard. So if the trial judge listening to that says, well, you know, you're all pretty much in the same boat here walking out of this marriage, you each get half the stuff, you each get half the debt, you each have the same income, therefore, wife, I deny your claim for permanent periodic alimony even though there's a presumption under 6108, and I deny your claim for fees because you have equal ability. That would not be an abuse of discretion by the trial judge, would it?
Absolutely not.
Okay, and so in your situation here today, tell me where I'm wrong, if we assume there's no abuse of discretion, the imputation of the minimum wage plus the 1407 in pension, it seems like it adds up that the wife is $27.46 a month income, husband's income is $36.04, but then from that, and I am giving it for your benefit, that number, then you take away the child support obligation, his income per month and your client's income per month seem about even. So how is it, I mean, it's a little bit different to the benefit of the husband, but how is that an abuse of discretion?
Well, the scenario the court presents now should be and can easily be distinguished from the case that we're here to decide on. And that is the imputation of income was improperly established because there wasn't enough, the burden was not met. What the trial court didn't do was deal with the fact that the parties came, when the dissolution trial was presented, the parties came with the wife having sole parental with 3 children, the husband historically being the breadwinner, and a substance abuse problem that didn't really show that the husband involuntarily was hampered in the way
What if the trial
presented.
judge just didn't think that? The trial judge made findings about his physical health, that he's unable to work anymore, and apparently did not give the substance abuse issue you're talking about as much weight as you think she should have, but isn't that her prerogative?
It is her prerogative, and it certainly would be a scenario where we don't have an argument before this court if she would have dealt with these issues in the findings, but she did not. There was nothing, I mean, the imputation of income to the wife to work a full-time job with 3 kids when she had sole parental responsibility, I just don't think.
One of the kids is an adult at the time. Because I think it mentioned in the final judgment, there was just, because child support was just for 2 of the kids.
Teenagers.
Teenagers. One who was almost going to age out, for lack of a better term, and may have aged out.
They were certainly older minor children, yes.
Okay, so, and apparently the trial judge didn't accept as readily your client's position about her health issues.
Correct.
Would that be a fair
The
assumption?
health issues, the fact that she...
Lupus and the things that...
The fact that she was alone with the 3 kids, and the fact that there wasn't a presentation of her work history that would allow the court to make that imputation finding.
Well, are you saying then, as a matter of law, there's error if I impute minimum, I mean, he didn't impute $75,000, he said minimum wage entry level, I'm going to impute that because you're 51 years old, or she said, you're 51 years old and you can go get a minimum wage entry job, and that's what I'm imputing to you because you got to go do something in essence.
There should be some history from the former wife that she could work a full-time job, that she has been working a full-time job at some point during the marriage, and
Under your scenario then, so if I was the, let's say, the stereotypical homemaker, and I raised the kids, and I didn't work outside the house, because certainly raising kids is significant work, but, okay, now my kids they're leaving the nest, or out, they're teenagers, and they don't want to be bothered by mom, which we've all had.
Correct.
Or dads, too. All right, so now she's 50, and what's to do? The trial judge is apparently saying, you have the ability to go work. You're not going to have to work as a scientist or an auto mechanic or whatever, but you can get an entry job somewhere, doing something, and I'm going to only impute minimum wage to you. That seems to be appropriate to do that, even if there's no history of working outside the house.
And the other aspect of the appeal
Or not an abuse of discretion to do that.
Yeah, and we raise both the denial of the alimony, but also the failure to consider nominal alimony. The facts presented in this case clearly show an unsettled factual situation. There was no clear evidence about how disabled the husband was or how, he raised health issues, but there was no testimony about what treatment or what long-term expectations there were about how these health issues were going to pan out.
There was some evidence, was there not, regarding, and there was just so much of it that I went through, and so you'll have to educate me on whether this was something that actually came into evidence or didn't. There was some piece of paper, though, talking about his disability with regard to his pension in the fire department. Am I saying that he was permanently disabled?
I think that's what allowed for him to keep his pension, because there was also testimony that his job with the fire department came to an end based on cause concerns. But yes, there was, that was, I think, what allowed him to keep his pension of $29.
But so there was some evidence of his disability outside his own testimony regarding the plethora of problems in hospital admissions and whatnot that he had had.
Right. There was, but there was also a tax return the year before they filed where they had $123,000 in income. There was evidence that he was working after he came to Florida when he was collecting his pension. So I believe the failure to consider nominal alimony in an unsettled situation with teenage children that are about to reach majority or getting towards that age for a 24-year marriage, I think this court can clearly consider that an abuse of discretion.
Was that requested at trial, nominal? If you don't award me permanent periodic, at least award me some nominal thing just to preserve that issue down the road?
Was that specifically requested?
In closing argument, whether it's written or oral closing argument?
I believe not.
Okay.
I believe not. And I do not know if that deprives this court of the ability to find that. But I think that the case law requires the court to engage as fact finder. And when I did the initial brief in this case, I was not aware, and I did not fully appreciate the fact that the court did not make any findings, even towards the very end of the record, where she says she's going to talk about or make some rulings as to time sharing. She goes ahead and just backs off and says she's going to refer it to a family counselor. My point being is the issue concerning abuse of discretion does not, I think, in light of the Perlow case and this court's subsequent treatment of it, does not strictly deal with whether the court abused its discretion in ignoring facts or not applying the law correctly, but whether or not it verbatim adopts a final judgment. The record is clear that the court asked the parties' lawyers to submit a final judgment and put it in Word format, and the record is clear that the court asked for the parties' lawyers to make findings. This court's treatment of Perlow, which is the U.S. Supreme Court case.
Are you saying that this final judgment that was signed is verbatim to what was submitted by the husband's counsel?
The totality of the circumstances as a appellate counsel has led me to believe that. Now, I have read the cases that this court has issued that talks about the Supreme Court case in Perlow, and this court has voiced a concern or at least a common sense need to make an objection when a final judgment is entered verbatim. The Supreme Court, as this court's noted in its Chetlam case, 984, 7 2nd, 614, wrote that a wholesale verbatim adoption of a final judgment by itself is not error.
But what's the time differential between when the proposed judgments were submitted by each side to when the circuit judge signed a judgment?
That's one of the factors, and at the end of September...
What is it?
The end of September is when the trial concluded, September 26th. The court entered its final judgment, I believe, December 26th.
And when were the proposed judgments submitted to the trial judge by respective counsel?
I can't speak to that. But I can say, and I gave Chetlam careful reading, nothing about this court's treatment of Perlow leads counsel to believe that the failure to object is grounds that would preclude this court from considering Perlow as a basis for abuse of discretion. I do want to briefly address the factors that the Chetlam case talks about as far as what things this court should consider in whether or not there's an abuse of discretion in adopting a proposed final judgment wholesale. In this case, the final judgment tends to read of the work of an experienced advocate instead of a neutral and detached magistrate. The fact-finding contained in the final judgment is not supported by the actual trial record and transcript. 3, the trial judge did not participate in the trial. She made rulings, evidentiary rulings, but at no point did she express her findings or what conclusions she
Doesn't that work against you, though? I mean, if, following the Perlow case, isn't the suggestion that if I'm making oral findings at the trial, and then 3 months later I enter a judgment that's inconsistent with my oral findings, but it mirrors what was submitted by your opposing counsel, that would be a better argument for you that the judge is not independently using her analysis in rendering her judgment, isn't it?
Respectfully, the factor, as I read it, the failure to make findings at the trial level gives the appellate court more cause that the proposed final judgments and the findings contained in it in any way reflects the trial court's...
Well, how can you say that? I mean, I'm a trial judge. I was a trial judge for 14 years. At the end of the trial, I could say, okay, I'm taking this under advisement. I'm not uttering anything about what my thoughts are. Please submit to me your proposed final judgments, and I will enter a final judgment in due course. You seem to suggest because I don't enunciate what I'm off the cuff thinking at the end of the case, that somehow that the judgment that I enter later on, because I haven't made those announcements, it makes it more problematic if I, at the end of the day, decide that one side's arguments and proposed judgments are in line with what I'm now thinking.
If you're reviewing the proposed final judgment, and as the appellate judge, you see in the record, well, the judge made this finding or made that finding. He or she pronounced it verbally. And then you can see, there it is in the proposed final judgment. But without that finding verbalized, you have no way of knowing if that in any way reflects the trial judge's...
You have no way of not knowing that.
You don't. And that's why the Chetram case looks at a variety of factors in deciding whether or not there's an abuse of discretion in the adoption of the proposed final judgment.
But I mean, one of the factors would seem to be, okay, I get a judgment from one side and I sign it automatically or within a matter of hours or day before the other side has had a chance to respond to that, saying, well, Judge, I've seen the proposed judgment from the other side, and that's not what the evidence, there's no evidence to support that, so we object to any of those findings.
Respectfully, Your Honor, I read Perlow, in this case, this court's treatment of Perlow, as a concern that the trial court should engage and should act as a fact finder. I think this case and the Chetram case raises an interesting issue for the appellate court, is whether or not a lack of fact finding, a lack of involvement by the trial court.
In essence, you're saying oral fact finding.
Yes.
Because there's obviously a whole reams of facts found here. You just disagree with whether that's originated by the trial judge or she just...
Just the trial court involving him or herself in the trial.
But this trial judge did involve herself in the trial and actually, questioned both the former wife and the former husband.
There were some points for clarification.
She did quite a thorough questioning of both of them at the very end.
I don't recall respectfully, and I defer to
Counsel, you're down to under 2 minutes if you want to save those for rebuttal.
Yes, thank you.
Good morning again. My name is Charles Willits, and I represent the appellee, Albert Rocklein, in this case. I will apologize. I'm catching a little cold. I'm a little hoarse, so if you do not understand me, please tell me to speak up. I did represent Mr. Rocklein throughout this 6 years of litigation, as I do now. And basically, I did not prepare this final judgment or have anything to do with the preparation of this final judgment. As an officer of the court, I represent that to this court. I don't even remember giving a proposed final judgment to Judge Schoonover. I think she did, in this 20-page final judgment, she did an excellent job. She notes on page 1 that she had the demeanor, the character of the witnesses, she evaluated the testimony. She states clearly on page 1 that I may not have put every non-essential fact in this final judgment, but I have considered all facts to render this opinion. Now, the Kennedy case, which my opposing counsel cites, was a case I brought to this court where Judge Adams in the lower court, in fact, equalized the incomes of the parties. My client was a banker making about $65,000 a year, and his wife was a school teacher making $37,000 to $38,000 a year. Judge Adams equalized the income. This court said you do not do that. The question in this, Judge Lambert, as you pointed out, and was part of my argument, is that these parties' income is almost exactly the same after the judge imputed income to the former wife of $1,300 and some odd dollars. Her income comes to $32 less than Mr. Rocklein.
Does that include the child support?
No, sir. He paid $825 in child support, Judge Ofinger, and I took the child support out because that's a deduction that he should have, and I did not include it in the former wife's income. What she basically had was
In other words, you reduce it from the husband's monthly total, but do not include it in the wife's monthly total.
Right, yes, sir.
What I'm trying to understand, though, is when his child support obligation ends, will their income still be roughly equal, or will he be $800 or $900 a month ahead of her?
He would be ahead of her, Your Honor. You're correct. There's still one child that's a minor, and the support is $525 a month.
Okay, so when that child reaches majority, then he'll be $500 and so ahead of her, assuming that they're in rough parity now.
Yes, sir. You're correct. And basically, at this time, the wife's income is exactly $27.47, and the income of the husband is like $27.78. I reversed that. I think it should be husband and wife. So basically, Mr. Rocklein is the most disabled person I have ever represented in my career as a lawyer. Basically, I can list them. I listed over a page in the brief: hip replacements, back problems, knee problems. He's almost died a few times. He was so disabled that during the trial, he got up and walked around, and the court let him do that because he could not sit in the chair due to his back, which requires metal plates in 2, 3, 4, and 5 on each side of his vertebrae. He has been in and out of hospital forever. He's a disabled firefighter from New Jersey, and basically we gave and we stipulated that she has $1,407 a month of his non-disability fireman's pension. And of course, this court is very much aware that disability is not subject to equitable distribution, period. Mr. Rocklein, they have no assets. They sold a home for $190,000. It was placed in my trust account. I still have $15,000 in that trust account pursuant to Judge Schoonover's ruling until this court has reached its decision. Otherwise, I've distributed $87,500 to both parties. The wife has the ability to pay her attorney's fees. She has the ability to support herself. She's lived with Darren Mitchell, cohabitated by her own testimony, since 2010. She still lives with him. He gives her a Cadillac Escalade to drive. She has rent-free. She has no utilities.
Well, she testified that she is required to pay half the rent. She buys her own groceries. She testified that she occasionally, I think, drives a Cadillac, but her car is the Suburban.
Right.
So there was some, the court, given the totality of the circumstances, perhaps did not believe her. I think that's fair to say. But she did not, I went back last night and read all of her testimony again, trying to pinpoint some things in there, but she never admitted that he gave her that car, or that he pays all her rent, or anything like that.
And that goes to the first page of the final judgment, Judge Berger, where basically the court says, and Kennedy says, a fact is not fact until the court finds it to be so. The fact that someone says it in a courtroom doesn't mean the judge has to accept it as fact. And I think that's exactly what Judge Schoonover did. I think being in that trial, if you read that transcript, I think you'll see that maybe Mrs. Rocklein was less than candid with the court, and the court felt that way. And basically to ask for attorney's fees when I've given her $87,500, and before, right after the court, as soon as I got that money, I was directed to pay her $15,000 out of the trust monies to pay for her attorney's fees. And I gave him a check, as I recall, when we walked in the courtroom. So her attorney was paid. And basically, if we talk about the need, as Judge Lambert brought up, and the ability to pay, Mr. Rocklein, even if he's not paying child support, if you take that away, his total income is like $3,600 a month. After he worked forever at the fire department, is disabled, cannot get himself corrected, continuous operations. And I would submit that if you look at the case law, there's no way that it qualifies for permanent alimony because he doesn't have the ability to pay, and also attorney's fees, she has the ability to pay hers.
Let me ask you about the issues involving the credits. Do you interpret the final judgment to be that the trial court concluded that your client owed retroactive child support, but then credited most, if not all of that, with payments that he had made post-separation?
I think the judge's exact ruling in the final judgment, sir, was that neither party has submitted any receipts, any canceled checks, or any items to document those claims, and therefore they were denied to both sides. Both my client's claim, she took $22,000 in rent, according to the final judgment. She took $9,500 in rent, according to the final judgment. If anybody's shortchanged, it's Albert Rocklein, not her, because he was paying her $2,950 or $25, I'm not sure, a month, and that left him $1,025 to live on from 2009 to 2013.
Going back over the final judgment, and I guess maybe I read it too quickly earlier as I was getting ready for oral argument, I was of the impression that there was a determination made by the judge saying, okay, you owe this back child support, but you don't actually have to pay it because you paid it in another fashion, and I'm going to give you credit for it. But as I read it, Judge Schoonover just says that the wife testified that the husband owes her $43,830.48 of retroactive child support and monies he did not pay under the earlier temporary agreement. And then Judge Schoonover goes on to find that the husband is owed credits against the jointly stipulated order. So did she not actually make a finding that, A, there is retroactive support owed, but I am going to reduce that balance based upon credits that I'm determining that he's entitled to? Is that your understanding of the judgment?
No, Your Honor. I was reading it yesterday, and it dawned on me. All of a sudden, at the end of that, on that page, I think it's 5 and 6, she says the parties have not provided proof as to any of these claims, and therefore they are denied. Nowhere in the order of the court does it deal with any set-offs, period, in the wherefore division, Your Honor. And I read it, and it finally dawned on me she never addressed that, period. She just said the claims have not been proved, they are denied for both parties. And I can read the exact language if you'd like me to. It was, although the parties made payments regarding the marital residence in New Jersey, neither party introduced any bills, canceled checks, statements, documents, expenses. Therefore, is hereby denied as to both parties. And that goes to all of these matters that she was covering.
That's in the paragraph on page 7, though, pertaining to expenses of the New Jersey home.
It is, Your Honor.
So I don't know that seems to be apples and oranges here.
And I'm not sure how to read that, because first off, she covers all the various expenses alleged by the parties, and then right under that, credits due to the wife, and then double I, she says that in the paragraph underneath there. So it seemed to me, and when you go to the wherefore division, the order of the court, there's not one sentence addressing that issue at all. So I had to read that as the fact that she said there's insufficient proof, therefore we will not, in any situation, give either party any relief. And that's what I think she did. And so basically, I mean, attorney's fees should not be an issue. I think it's almost hornbook law. Alimony, if we talk about, there's innumerable cases where a party makes $40,000, party makes $65,000. There's no alimony in those cases because there's no need or ability to pay. And just as you said in Kennedy, you can't equalize the incomes. And if he were forced to pay Mrs. Rocklein, he would in fact be the party that would be in complete abject poverty if he did so. She also said, you know, regarding the credits, just so the court will know, we agreed to pay the $2,925 to the wife, left my client very little funds, because they had 3 children, and the order said that we can, in fact, adjust that at the trial of this matter or later on in the cause. And that's exactly what we did at trial. And that's what I think the ruling of Judge Schoonover was in this case, Your Honor. And basically, it's brought up in the brief that my client has a drug problem. I don't know where that came from. Absolutely, it sort of floored me. I don't know of any drug problem he'd have. He doesn't. He's certainly on medication. If anybody who has illnesses he has would be on substantial medication. And he is. And so basically, it comes down, you know, the credits were denied both parties. That's count 2. Count 1 and 2, there's no ability to pay. I think that takes care of that. And then the only remaining issue is clearly in his favor.
Let me ask you about the imputing the wife's income. There was a finding in the final judgment that says she was denied Social Security disability, and that there was no evidence that her health issues prevent her from maintaining a normal, active lifestyle. And I went back and and you mentioned it in your brief, and you cite to the record on appeal, but you cite to the trial court's final judgment and not to the transcript. And I went back, and I think while there was some questions about it, there wasn't really much follow-through in terms of, because there were objections back and forth, and so I couldn't find in the transcript, having read the wife's testimony, where that came into evidence. There was some document that you started questioning her about with regard to I guess the doctor said she didn't have lupus or what. I'm assuming that's what the document said, but I didn't see that was actually admitted into evidence. I think it went on to other things, and she denied applying for the Social Security benefit. So I'm wondering, is that finding supported by the record? Because I couldn't find it, and if it's in there, could you point me to where it is?
Her ability to work, Your Honor?
Yes, and the fact that she was denied, her ability to work appears to me, based on the fact that she was denied Social Security disability benefits after applying for it, and I didn't see where that came into evidence.
The court stated, Your Honor, that in fact she applied for Social Security disability because she claimed that she had lupus, and the court said that there was no evidence to prove that, and she rejected that argument. And number 2, she was a court reporter in the state of New Jersey for 15 years, and she has the ability to work in a pretty high capacity, and all the court imputed to her was minimum wage of $7.78 an hour. So she obviously has the ability to work. She's cohabitating with another man who's providing her with, if the court wants to believe that she doesn't have the Cadillac Escalade to drive, she does have the rent and the utilities paid for. Mr. Rocklein does not have any of those things, and he survives right now on $2,700 and some dollars a month.
Did she testify that the paramour pays the rent and the utilities? Did Miss Fahey testify that, was it Mr. Mitchell is paying the rent and the utilities?
Yes, sir, I did ask her that.
And she said yes to that?
You know, Your Honor, I don't misrepresent anything to the court. I'll tell you the truth. I don't remember I think she admitted to that, but I don't want to tell you anything that's wrong. And I tried this case, but I don't want to misrepresent what happened. To my recollection, that's correct, but she would not admit on the Cadillac Escalade, but if I'm wrong there, please correct me.
My recollection of her testimony was that she paid half. She paid half of the rent, she paid half of the utilities, she paid half of everything, and that she was thinking she might have to look for a room someplace else because he was tired of maybe supporting her, maybe that's what she said, of the money issues. But and then there was some cross-examination of her with regard to, which probably goes to the credibility issue from the trial judge. I believe there's some cross-examination of how is it that you're running a $100,000 deficit every year. Explain that, and I don't believe that she was able or willing to explain that, but that's my recollection of that line of questioning.
Your Honor, you are correct. I withdraw what I said to Judge Lambert. You are correct that she did deny that she paid half of it. You are absolutely correct. I think Judge Schoonover did not believe that, and she chose to say that was not a fact in this case because she looked at the demeanor and the character of the witness, and she did not say that was, she did not believe that, period. So, and this was a contested matter. We went all day one day, and I think we tried another full day, at least 4 hours, if not more. I think it was another full day. And we came back, and Judge Schoonover had it for some period of time to write the final judgment, and it's correct. It came out about 3 months later, and she had written it herself, and I would submit in all respects it was a very well-written final judgment. She made numerous findings. She did, all the things into the debt. They also appealed the debt.
So your recollection is she did not request either side to submit proposed final judgments?
I do not believe she did, Your Honor. It was a very difficult case in the sense that she wrote a lot better final judgment than I myself would have written. And it was more detailed. And if I gave her something that was just boilerplate quick, I certainly don't recall that. I don't think I did, Your Honor. And then she talked about the debts to her family, if that's an issue here, and I don't know whether it is for the court. But basically, Mr. Rocklein was ordered to pay $2,500 to Joy Fahey, her sister, because he knew of that debt. And the judge found that all the other debts he had no knowledge of. One time she took out a domestic violence restraining order against Mr. Rocklein, and the sister or the brother testified that they had had a conversation together on the phone. The judge found that to be untrue because he could not do that with the domestic violence restraining order. So I appreciate your time. Is there any more questions that I could address?
Thank you, counsel.
Thank you very much.
Thank you. Very briefly, in response to your question, the very end of the transcript, the court clearly requests that the proposed final judgment be submitted by both parties in Word format.
Well, let me ask you the question about the credits. Do you interpret the final judgment to be that the trial judge found that there was a non-payment of child support of the $43,000 and change, and then awarded credits to the husband against that to basically net it out?
I think the record is unambiguous that there was $43,000 in unpaid support.
Did the husband testify to that? Say, yes, I agree.
It was either testified to or specifically made reference to in the record. But I specifically, when I was preparing this, made sure the record, and it was presented to the trial court, the $43,000 number, and that is...
You agree that the final judgment doesn't make that, there's no specific finding in the written final judgment that says I find that there's retroactive child support of $43,000, but then I award these credits against it.
Now that you say it, yes, the final judgment does talk about the $43,000 in unpaid support.
It says that that's what she's testified about, but it's not a finding by the judge saying, and I agree that there is $43,000 and change owed.
I can't recall that, but I do submit that the record, whether it's in the final judgment, is explaining it, or identifying it to be specifically that, the record does. And the appellate cites the Rodriguez case as the court should find compelling equitable considerations before applying or granting a set-off against support. In other words, Rodriguez case emphasizes the importance of support as compared to other debts.
All right, counsel, you've exhausted your time.
Thank you.
Thank you both. That'll conclude our session for the day, and we'll be in recess. Thank you.